I I would please like to have that question answered. Let me ask first, are we on the record? Is there a court reporter present? Uh, Phyllis K. Webster, will you please recite your oath of office into...
And that's what I'm going to call now, because it looks like it's between Mr. Doose and Mr. Cochran. Well, I can't call, yeah. Mr. Doose, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward Doose, with Jared Regier for the state, Mr. Doose in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. Doose led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand, and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. Doose, at this time, you want to talk to Mr. Patterson?
All right, folks, strap in, because this isn't your typical courtroom hearing. From the very first second, Anthony Edward Doose sets the stage for chaos, demanding the record, questioning the court reporter, and even insisting the judge recite her oath of office. This is a masterclass in sovereign citizen tactics, loud, confrontational, and straight from the internet playbook. What we're about to see isn't just a traffic case. It's a performance. Expect arguments that bounce between legal reality and internet-fueled fantasies, a judge forced to remain professional under pressure, and every ounce of courtroom drama condensed into a single hearing. Stay tuned, because things get messy fast.
Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations.
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by...
Here's where things get interesting. Anthony is determined to represent himself, but the judge wisely keeps standby counsel Darren Patterson on hand. Standby counsel is like having a safety net. If the defendant hits a legal wall, the lawyer can step in and prevent disaster. And make no mistake, Anthony's insistence on self-representation isn't bravery. It's risky. Representing yourself in court, especially with alleged traffic violations, sounds simple until constitutional arguments, jury trial rights, and case law come into play. Patterson knows the system and is ready to intervene, but Anthony, he's already setting the stage for conflict, refusing to accept even minor legal guidance.
I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. Doose, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed.
Notice Anthony's signature move here, declaring he's appearing under threat, duress, and coercion, while labeling the state of Kansas a corporation. This is classic sovereign citizen rhetoric. It's dramatic, confusing, and designed to disrupt the courtroom flow. But the judge isn't buying it. She calmly reminds him the case is a straightforward traffic matter. What's fascinating is how Anthony elevates something simple, expired registration, no insurance, into a full-blown constitutional debate. This isn't strategy. It's performance art in the legal arena. And the tension? You can feel it even from just reading the transcript. The drama is real, and it's only escalated.
But does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law.
Now we get to a critical moment, the jury trial debate. Anthony claims he wants a trial, but confusion ensues over whether it's a jury trial or bench trial. His standby attorney, Patterson, clarifies that under constitutional law, he absolutely has a right to a jury trial. The potential sentence could be up to a year. This is where statute law and case law collide, and the courtroom tension spikes. The judge navigates this perfectly, acknowledging Anthony's rights while keeping procedural framework intact. For viewers, this is a masterclass in courtroom dynamics. Constitutional rights, procedural rules, and human drama all playing out simultaneously. The stakes feel higher than a simple traffic infraction, and Anthony's insistence on bending the rules keeps everyone on edge.
Your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. Doose, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. Doose, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here.
This part is pure textbook chaos for self-represented defendants. The judge patiently explains that representing yourself means knowing your law, citing statutes, and making coherent arguments. Anthony refuses, claiming attorneys serve the courts, not the people, and launches into claims about illegal arrest procedures. Here's the key takeaway. Without legal knowledge, self-representation is a double-edged sword. Anthony thinks he's uncovering loopholes, but the courtroom reality is harsh. Judges like this one must balance fairness with maintaining order, and the stakes grow exponentially when someone rejects professional guidance while attempting to navigate complex legal terrain.
For this purpose, so here's the thing, Mr. Doose. No, let me talk now, Mr. Doose. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest.
All right.
For
Well, we're not going on
22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. Doose?
May I ask that there be an extension so that way I may fully research the procedures of the administrative.
Now we dive into the administrative law rabbit hole. Anthony insists he's being tried under administrative law and demands extra time to research procedures. The judge is patient but firm, reminding him this is a criminal traffic trial. This is a recurring pattern in sovereign citizen cases. Defendants conflate specialized legal concepts with their own interpretations. It's fascinating because the courtroom becomes a tug of war between legal reality and internet-fueled fantasies. Every pause, objection, and clarification escalates tension, and you can almost feel the collective patience of the court staff wearing thin. For viewers, it's a gripping mix of absurdity and legal procedure.
Administrative law judge, that is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for.
Finally, the judge set the firm jury trial date in October 2024, with pre-trial at the end of September. Anthony reluctantly agrees, but keeps pressing for the judge to read her oath, a ritual the court has no requirement to repeat. This repeated insistence is classic delay tactic behavior, a hallmark of courtroom theater. The energy in the room is thick as Anthony continues declaring, "I don't consent," and questioning jurisdiction. What's remarkable here is how procedural patience meets defiance. The judge maintains professionalism, the standby counsel watches closely, and Anthony continues to perform his personal brand of legal theater. This scene captures the tension, absurdity, and unpredictability of self-representation perfectly. To summarize Anthony Edward Doose's case is a vivid example of self-representation meeting legal reality. What started as a simple traffic hearing evolved into a dramatic display of constitutional debates, sovereign citizen tactics, and courtroom patience. The judge handled it with poise, setting clear trial dates, reaffirming procedural rules, and ensuring justice moved forward despite repeated disruptions. For viewers, this is a reminder. Understanding your rights is critical, but navigating the courtroom without legal expertise can quickly spiral. If you found this case as shocking as we did, hit that like button. Share your thoughts and comments, and don't forget to subscribe for more jaw-dropping breakdowns and courtroom drama.